This particular piece of property is within the urban service boundary. It's been within the urban service boundary, I think, since at least 1980, when I was still in law school. I mean, there is no way that the intention, in my opinion, having sat through all those meetings, there is no way the joint planning agreement, inter-service boundary agreement, interlocal boundary service agreement, was ever meant to apply to the situation where we find ourselves today. Potential incompatibility shall be mitigated through techniques including but not limited to, and it lists 1, 2, 3, and 4. It lists 4 principles. I'm not going to read them, but at the last meeting in the record, we showed how this proposed project meets all 4 of those. In fact, in my opinion, it goes even further. The mitigation techniques go even further than what the joint planning agreement calls for. No wonder, and by the way, I think the county knows this. So no wonder you're being told it's not about any particular project, it's about the process, which makes it doubly frustrating for my client and just doubly wrong to continue this over a process issue. Where we ended up after 4 years happens to meet all the county's compatibility standards. We often to explain that to the county commission on the basis of, you know, before you go have a big fight with the city of Venice about this, at least hear from us and have us explain to you the facts of this, and perhaps then you'll realize there really isn't any issue. They declined that. Now, I do understand the county commission doesn't want to get into a situation where they're holding sort of companion, you know, land use review public hearings. I do understand that. Yet, still, they've invoked this dispute resolution process, which I don't think the facts of this situation allow them to do it, but they've done it anyway, and then they've threatened to sue you about it without ever once hearing from my client as to the facts and the circumstances of this particular rezoning. And I know the county commissioners. They are all 5 reasonable people. I practice before them. I go to meetings with them. I see them all the time. They're all very reasonable people. I'm fully confident that had they just been willing to have heard all of the different things we've done with this project, they would realize there is no compatibility issue. What's driving this is one property owner, Dr. Robert Burris, and the Sorrento Ranches Homeowners Association, who have not only objected to this project, but several others in the area. And that's what's behind all this, and that's what's driving all this. And now my client is going to suffer another delay, and its due process rights are now, I believe, being damaged. In summary, then, we do not want to see, in summary, then, the county has threatened to take the city to court. I mean, what a ridiculous, crazy situation this is. Where they agreed with you in a joint planning agreement to allow for either greater densities immediately adjacent to this property. It's just this is nuts. But nevertheless, they've threatened to sue the city. We don't want to see the city and the county end up in court. So we are okay with the continuance today, provided that at the next date that the county makes an effort to resolve whatever needs to be resolved with you by the August, was it 8th, Mr. Mayor? Thank you. By the August 8th City Council meeting. That would have given the county 5 weeks.
It's August 14th.
August 14th. Thank you. Even longer. 14th.
What I don't understand, and I guess I'm articulating the same thing Mr. Wilson articulated, when Mr. Lay writes us and says this is not about this particular project, well, if they're going to sue us to get an injunction or a stay of the proceedings, then it is about this particular project, whether they say it is or not. Now, if we're going to postpone these proceedings until the 14th of August, that's 3 weeks, I would simply encourage staff, city manager, city attorney, to get together with the county staff to see if they can hammer out some resolution of this matter that will avoid a lot of delay in this particular application.
There were several waterfalls that happened all towards the end of the week, and we were at a bit of a disadvantage because city attorney was not available when he got back. His system was down, so he hadn't been able to get up to speed. So we need to give him time, to give us guidance, certainly from a legal interpretation point of view. Actually, I would have gone forward to let us sue us because I'm looking forward to the arguments on the thing, because I think, number one, they're misinformed. Number two, I don't think they're getting the right support. Number three, they refuse to listen to what the reasons are and have chosen a litigious route, and I don't think it's right.
Mayor, I think we're going to end up in court, whether it's
No,
on this
let's
particular...
get this over with and get on with it. But
I
I
think
would support
eventually...
the motion.
Don't do that.